Good morning. I'm Alice Newland, President of the League of Women Voters of Manatee County. I welcome you to today's hot topic presentation, the Equal Rights Amendment. Where are we now? This program is being recorded and will be available on the League of Women Voters of Manatee County website, LWVManatee.org. It is the property of the League of Women Voters, and no part can be copied or reproduced without written permission from the League. Our speaker, Rebecca Goldman, will be answering questions at the end of the presentation. Please put your questions in chat and submit them to Ruth Herenjar, our League's Vice President. She will present the questions at the end of the presentation. The League of Women Voters of the United States has supported and pushed for ratification of the Equal Rights Amendment since it was first passed by Congress in 1972. And I'm going to interject a personal story from that same time frame. In 1977, I was working as a junior accountant at Pete Marwick Mitchell, and my mother was in AAUW, American Association of University Women, and their fundraiser was to make these big key fobs that were kind of using yarn, and it said ERA on it. So I was working in South Philly in a very Italian area in a trucking company doing an audit, and you had to hand your key in at the front desk so they could move the cars around as the trucks came and went. And towards early afternoon, the senior on the job came up to me very disturbed and said, "You have to go down there and talk to those women at the front desk. They think you're a women's liber." And I said, "But I am." And I said, "And why wouldn't I want to have equal rights?" So it's been a while, but it's all within our memory of this push to get this passed. In January of 2020, Virginia became the 38th and final state needed to ratify the ERA. As the ERA has met the requirements to be added to the U.S. Constitution, it has been passed by Congress and 3/4 of the states. The League is pushing for Congress to officially recognize it as the 28th Amendment. Our speaker today, Rebecca Goldman, will give you the background of the amendment, why it is important, what the League is doing, and what we can do to get equal rights for the women enshrined in the Constitution. Rebecca Goldman is the Justice Reform Legislative and Policy Specialist with the League of Women Voters of the United States, a member of the Advocacy and Litigation Department. Rebecca supports the League of Women Voters of the United States and League affiliates in developing the League's national policy agenda and campaign strategy before Congress and the administration, as well as advancing state and local initiatives on the League's urgent issue areas. She also supports the League in implementation of the advocacy efforts. Prior to joining the League, Rebecca served in the nonprofit sector, addressing sexual and reproductive health rights, economic inequality, and food insecurity through research, advocacy, and public education and direct service provision. So, in advance of the 2020 presidential election, Rebecca volunteered to assist in voter registration, education, and mobilization. So thank you, Rebecca, for agreeing to do this presentation, and it's all yours.
Wonderful. Thank you for that very generous introduction. As Alice said, my name is Rebecca Goldman, pronouns she, her, and I'm the Justice Reform Legislative and Policy Specialist with the League of Women Voters of the United States. And Alice or Ruth, is someone going to share the slide deck just so folks don't have to look exclusively at my face as I'm presenting? Wonderful. Thank you so much. I'm delighted to be here today speaking with you about the Equal Rights Amendment, or ERA. Alice's anecdote was a wonderful way to get us started, and I do think that this is a particularly good way for us to honor Women's History Month, particularly as this year marks the 100th year since the ERA was first introduced in Congress. Now, I clearly stand on the shoulders of giants, and I presume that some of you have worked on this issue for a very long time. I do still think that one of the best ways we can propel it is to ensure we're speaking about it with a unified voice. So as Alice said, I'm going to go over some background and talk about its relevance today and to the League's work. And I want to provide the caveat that I am not an attorney, so while I work amply on this topic, there may be legal or litigative questions that I'm not qualified to answer, which I'm always happy to refer to an appropriate colleague. And as a friendly note, you will have access to this deck of slides later, so don't worry about copying everything down. And you'll also have all of the links in the PowerPoint, which bring you directly to additional resources. So as an overview, we'll go over the ERA text and why it's still significant today, the ERA's ratification history, the issue of a time limit, a congressional solution, the League and the ERA, including some of the League's recent federal advocacy work, and then resources for your work. And can we go to the next slide? So the ERA is brief and has 3 sections. Section 1 is 24 words designed to constitutionally protect the equality of rights under the law for all, regardless of sex. And as you can see on the screen, it reads, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Section 2 of the amendment gives Congress enforcement power, and Section 3 says that the amendment takes effect 2 years after ratification. Now, people may wonder why we still need the ERA, especially in light of the 14th Amendment's Equal Protection Clause and individual federal laws against different forms of sex-based discrimination. And this is a valid question. Protections under the 14th Amendment haven't been interpreted consistently to apply to sex in the same way that they do to other characteristics like race. And so there's limited legal recourse for people who experience sex-based discrimination, including discrimination in the application of federal laws. As a result, women and other individuals continue to face discrimination on the basis of sex, and this is clear in ongoing fights against unequal pay, workplace harassment, pregnancy discrimination, domestic violence, limited access to comprehensive health care, and more. The ERA would raise the standard for judicial scrutiny of claims of sex-based discrimination by the government. It would also provide a legal defense against the rollback of women's rights, because just as Congress can institute laws, they can institute new laws that override previous, and it would pave the way for additional legislative progress towards sex and gender equality. Next slide, please. So the constitutional amendment process is established by Article 5 of the U.S. Constitution. And I know this is something that Alice mentioned in the introduction. Typically, Congress files a joint resolution with a proposed amendment, which it must pass with 2/3 majority in both houses. The proposed amendment then goes to the state legislatures, where 3/4 of the states, or currently 38 states, must ratify it. And as Article 5 says, when an amendment meets that 3/4 state threshold, it's a valid part of the Constitution. Then the National Archivist, who heads the National Archives and Records Administration, certifies that the amendment is valid through a formal proclamation. So turning to the ERA, in 1972, more than 50 years ago, Congress passed the ERA with well over the necessary 2/3 vote. And in January 2020, Virginia became the 38th and final state to ratify it. So as the ERA has met all ratification requirements, and we're now more than 3 years from ratification, meaning we've passed that effective 2-year waiting period, the calls continue to formally complete the amendment process, officially recognizing the ERA as the 28th Amendment. Next slide. So why isn't the process complete? And here we get into an issue of time limit. So when Congress passed the ERA in 1972, it included in the amendment preamble a 7-year time limit for states to ratify it. And this is an important note here. It was the amendment preamble, not the amendment text itself. This gets into legal arguments in opposition of the ERA. In 1978, Congress extended that time limit by 3 years. But in 1982, when that time limit came up, ratification of the ERA was still 3 states short. The end of 2018, ERA ratification was just 1 state short. So the National Archives and Records Administration contacted the Department of Justice's Office of Legal Counsel, or OLC, asking for guidance on what the archivist should do in the event that a 38th state ratify it. In January 2020, the OLC did issue an opinion. It said that Congress had the constitutional authority to impose a ratification timeline when it had in the 70s, but may not revive a proposed amendment after its ratification timeline has expired. So the office said that because 3/4 of the states didn't ratify the ERA before the timeline, the ERA is no longer pending before the states and could not be certified. And 2 days later, the National Archives and Records Administration released a statement saying that it deferred to that opinion, meaning the archivist at the time would not certify Virginia's ratification that year unless otherwise directed by a court order. In January 2022, 5 Congress members sent a letter to the OLC urging them to withdraw that 2020 opinion. And then the OLC issued a follow-up statement saying that they maintained their previous opinion, but that it did not preclude the judicial branch from considering the constitutional status of the ERA or Congress from acting on ERA ratification. Shortly after, President Biden issued a statement also calling on Congress to pass a resolution recognizing ERA ratification. So I know that's a lot of background and it's a lot of back and forth with the administration, but this is a large part of what's informed the League's advocacy strategy. And this is really important because sometimes ERA advocates disagree on strategy. Some constitutional scholars specify that Congress doesn't actually need to take action because, as we've discussed, as all of the ratification requirements have been met, the ERA is a valid part of the Constitution. So some of those folks have put pressure on the president to push the archivist to certify the ERA, and that's legitimate. But the League has strategically decided to focus our advocacy efforts on Congress because, again, the OLC and President Biden have pointed to Congress, and Congress is currently considering a good solution. Next slide. Thank you. So this brings us to a congressional solution. There's a joint resolution in U.S. Congress that affirms that the ERA is a valid part of the U.S. Constitution and that addresses the question of a ratification time limit. In the Senate, it is S.J. Res. 4 and was introduced by Senators Cardin and Murkowski, so it's got that bipartisan introduction. The Senate Judiciary Committee has already held a hearing on the ERA and that joint resolution the end of February. And Senator Schumer has said he will place the resolution on the Senate calendar for a floor vote this month. The resolution's text is identical in both chambers. And the House version, H.J. Res. 25, has been introduced by Representative Presley. Now, this joint resolution is similar to the one in 117th Congress, which also addressed the issue of a time limit and passed in the House with bipartisan support. At the time, it did not go to a vote in the Senate, but of note in the Senate, it was co-sponsored by the entire Democratic caucus, as well as Senators Murkowski and Collins. And so when we look at that similar joint resolution in the previous Congress, it might give us some indication as to what kind of support it would have in the current Congress. Next slide. And this brings us to the League and the ERA. Thank you. So the League's work on the ERA is rooted in our equality of opportunity position from impact on issues. And as you can see on the screen, the League supports equal rights for all under state and federal law, regardless of sex, as well as a multitude of other characteristics. The League also supports ratification of the ERA, or final ratification of the ERA, as well as efforts to bring laws into compliance with the goals of the ERA. As Alice said, we've pushed for ERA ratification since it was first passed by Congress in 1972. And just so you know, at LWVUS, we do our ERA advocacy work in coordination with the National ERA Coalition. And at the League's 2022 National Convention, delegates voted to add the ERA to LWVUS program, which is wonderful. As you can see on the screen, the program addition reads, I move that the Equal Rights Amendment be added to the LWVUS program so that resources and focus be used to accomplish its passage and further our mission. And this passage on the part of League delegates continues to inform LWVUS's ERA work. So thank you for that. So to give you a sense of the League's ERA federal advocacy strategy, I'm just going to quickly go over our top lines from 117th Congress. In 2021 and 2022, LWVUS included the ERA in its priorities to the new Biden administration. We sent a letter to members of the House urging support of their resolution and then released a press statement commending its passage. We sent a letter to the Senate urging support of their resolution and released a press statement commending President Biden's Women's Equality Day proclamation that expressed the need for the ERA. In terms of our congressional advocacy, we sent a letter to Senator Schumer urging him to schedule a Senate vote on the resolution. Weighing an executive branch option, we sent a letter to the White House Gender Policy Council, urging them to advise President Biden to instruct the archivist to publish the ERA. Additionally, we worked on a long-term initiative in which state leagues wrote to their senators on the Senate resolution, and then we sent a package of those letters again to Senator Schumer to demonstrate nationwide support for bringing that to a vote. And we utilized an action alert for the Senate legislation. So as you can see, we've done executive advocacy, emphasizing the need to prioritize the ERA, but the majority of our focus has been garnering co-sponsorships and votes in Congress, as well as actually trying to get that vote scheduled in the Senate. Next slide. Thank you. So for 118th Congress, we hit the ground running on February 1st, the day that Congress publicly announced the joint resolution in both chambers. We published an action alert so people can urge their Congress members to support the current legislation, and we sent out an email to League members and supporters and utilized Outreach Circle with our League affiliates to maximize the reach of that action alert. And we had a very successful push within the first couple days. LWVUS also submitted written testimony for that Senate Judiciary Committee hearing that took place the end of last month. Next slide. Okay, so that's a lot of background. It's a lot of background on what the League has done, and this is probably why most of us are here. What can you do? As we know, change is incremental, and oftentimes passage of major bipartisan legislation requires its reintroduction in multiple Congresses. And this is why we need to keep showing up and helping demonstrate a track record of bipartisan support for this vital issue. And a lot of change starts with public education and public opinion. So coming here today to discuss the ERA, to understand its nuance, and to identify ways to talk about it is actually a really important advocacy opportunity. So firstly, I've pulled out some top-line bipartisan talking points. And as you can see on the screen, those include the ERA will constitutionally protect the equality of rights under the law regardless of sex. Simple enough. The ERA has met all ratification requirements. Let's continue to reiterate that because, again, when it meets all ratification requirements, it's a valid part of the Constitution. Women continue to face discrimination based on sex, and this is clear in ongoing fights against unequal pay, workplace harassment, pregnancy discrimination, domestic violence, and more. SJ Res 4 has been co-sponsored by Senators Cardin and Murkowski and will simply affirm that the ERA is a valid part of the Constitution and address the question of a ratification time limit. And this piece is really important because we know when we're speaking to our elected officials, they have a responsibility to respond to their constituents. Nearly 75% of Americans support the ERA, according to recent polling from AP and NORC. LWVUS also has resources for local and state leagues. If you go to the League Management site, or LMS, LWVUS has an ERA toolkit, which we've recently updated. It's also got its own talking points, many of which will overlap with what we've discussed here today. It's got frequently asked questions, graphics for your social media, and more. The toolkit includes a letter to the editor template, and in that LTE, if you open it up, you'll see that it talks about folks actually contacting their senators. So just a friendly reminder that local leagues must contact their state leagues before contacting or calling upon their senators to take action. And the toolkit also includes the LWVUS action alert to contact your senators and representatives, which I've also pulled out here on this slide for your ease. And that's something that anyone can use because it's an official LWVUS call to action. And with that, I would be more than happy to take any questions you have or expound upon anything that we've discussed.
Thank you. Thank you. Let's just go ahead and we do have go to Ruth, and Ruth, do you have some questions in chat?
I do have a question from Diana Shoemaker. The question is, what does it mean in SJ Res 4 that it will address the question of ratification timeline?
That's a great question. So if you read the text of SJ Res 4, which you can do on congress.gov, it actually talks about the ERA having met all requirements, right? It's been passed by Congress and ratified by 3/4 of the state, so it's a valid part of the Constitution. And it basically says, notwithstanding time limit, where I think it uses the term deadline, this is a valid part of the Constitution. So that's where it addresses it. It doesn't get into the back and forth about whether a time limit was constitutional at the start, where Congress derives its authority. And I'm more than happy to talk about those questions separately. But the resolution itself simply says, notwithstanding a deadline, this is a part of the Constitution.
Okay, Ruth, do you have any more, or shall I flip to some questions I've gotten otherwise?
I don't have any other questions at this time.
Okay, next question, which I was about to send to you, is how will this affect abortion rights? There's been 2 states that have used an equal rights provision in their state constitution to knock out restrictions that the legislature had put on abortion rights. I know you're not a lawyer, but how there are people that oppose it, that have part of the reason they oppose it is they oppose abortion, and they feel that if the ERA passes, that it will open the door to unrestricted abortion.
So as Alice is suggesting, states have their own constitutions and they can pass their own constitutional amendments, and plenty of states have passed their own equal rights amendments. Some of those are very expansive, which the League has oftentimes been a supporter of in the past, and some will explicitly talk about non-discrimination on the basis of pregnancy outcomes, including abortion. As we've discussed, the Equal Rights Amendment, which would be applied to the U.S. Constitution, is very limited and does not speak to reproductive health care. So let me pull out for a second and talk about judicial scrutiny. And like you said, I'm not an attorney. The application of judicial scrutiny is going to be subject to the discretion of a judge and a court. So it's all postulation exactly how the ERA would be applied. But the way it currently works, federal and state laws that differentiate on the basis of race are subject to what's known as strict scrutiny. It is the highest level of judicial scrutiny. So there's a very high level of proof that's required on the basis of governments to justify differential treatment. And it must be done so by the least restrictive means. When we look at laws that differentiate on the basis of sex, it is not held to the same level of judicial scrutiny. So there is not the same expectation of a demonstration of proof on the part of governments to justify that differentiation. The Equal Rights Amendment would raise the scrutiny, the judicial scrutiny required. So it would ensure that, well, ideally, it would ensure that courts are treating sex very much in the way that they do race, so that laws that have a discriminatory effect would not be considered constitutional. So we can postulate about the impact on abortion, but this speaks more to sex discrimination in laws. And when you hear talking points about unrestricted abortion, I'll just say as a case study, there are plenty of states that have equal rights amendments that look much more like the text of the ERA we're looking to finally publish in the US Constitution, and they still have ample restrictions on abortion.
Okay, thank you. What about the argument that there are state laws that give preferential treatment to women, or even federal psych, women, the WIC, women, infants and children, Social Security benefits for stay-at-home moms, and some that argue against the ERA say that it would take this preferential treatment away from women.
Okay, yeah, that's also a great question, because we want to know what are unintended impacts that could potentially be harmful. So we've already laid the groundwork of the fact that the ERA should change the judicial scrutiny of laws. And again, let's turn to the states with ERAs as a case study for the impact of the ERA on government-funded programs. We see that states with ERAs are permitted to maintain their government-funded programs as long as they are applied in a sex-neutral way. So the presumption is that that application at the federal level would look the same, that it shouldn't be diminishing people's benefits, but that they would be doled out based on need and familial structure and roles rather than sex. And that's actually the direction in which we want to move, because we wouldn't want benefits that are doled out based on sex stereotype. They should be applied based on need. So again, using those states as a case study where they're applying state funding for benefits, the presumption is that would look very similar at the federal level.
Okay, I'm not sure there's an answer to this one, but there is an argument that you are taking away states' rights and transferring a large amount of power to the federal government, and the federal government is less responsive than local governments are.
Okay, yeah, so when we talk about states' rights, there are plenty of existing amendments, I believe 8, but don't quote me because I would have to go back through, that already provide the same language that we're seeing in the ERA, giving Congress enforcement power. So we have a precedent that Congress does have the power to enforce existing amendments. Additionally, if we want to talk about state rights, it's interesting when opposition to the ERA suggests that this is a diminishing of state rights, because we're missing this massive piece that is, states have the right to ratify the US Constitution. It's the reason that 3/4 of the states, which is a very high threshold, must ratify the Constitution. And 38 states have. So if we don't respect the states' ratifications, we're actually removing a vital state right.
Oh, you led right into another question. 5 states have rescinded their ratification of the amendment over these years, this 50+ years since it was originally passed by Congress. What is the legal precedent for saying that they ratified it when they turned around and said, no, we've changed our mind? Number one. Number two, even if there is legal, isn't that kind of like, do people really still support it if their state no longer wants to have the Equal Rights Amendment passed?
So just a distinction, there are states, you're right, there are 5 states who have said that they want to rescind the ratification. They haven't rescinded the ratification because that's not permitted. Under the passage of the 14th, 15th, and 19th Amendments, there were states that said they wanted to rescind their ratification, and those states were never permitted. In the final publication of those 3 amendments, those states who claimed they wanted to rescind were listed as having ratified those amendments. Additionally, the National Archives and Records Administration, who oversees and arbitrates the process for amending the US Constitution, has already come out and said that when a state ratification is finalized, it cannot be removed. It is conclusive and final is the language. So the precedent, the legal precedent, is that unfortunately for those states where it's apparently the legislature will to remove the ratification, that is not permitted. And I cannot speak to how representative the legislature in each of those 5 states are of the constituency, but I can tell you that if 75%, approximately 75% of the nation supports the ERA, there might be some kind of discrepancy in the actions of the legislature.
Thank you. I'm going to give just a tiny bit of background here. The 13th, 14th, and 15th Amendment, probably everybody knows, but those were passed after the Civil War, which gave rights to African Americans. The southern states passed them so they could be readmitted to the Union. It is quite understandable that subsequently they wanted to rescind it. And I can see how it came about that they said, no, you can't do that. Anyway, we'll give you a real softball one. The ERA will impact privacy and safety of women by removing gender designations from bathrooms, locker rooms, jails, and hospital rooms.
Okay. So, Alice, I appreciate the question because it does seem that a lot of the talking points in opposition to the ERA are fear-mongering, and they do instill fear in folks who are concerned about a sense of privacy or safety in physical spaces. But as we've discussed, when it comes to the judicial scrutiny that's applied to federal and state laws, there is not an all-out prohibition on distinctions on the basis of sex. There would be a high judicial burden of proof, essentially, in layman's terms, to justify that distinction. And again, it comes down to judicial interpretation. I can't tell you how the Supreme Court is going to rule, though probably based on recent rulings, we can make some kinds of educated postulation. But the Equal Rights Amendment does not prohibit any kind of distinction on the basis of sex. It would change that level of scrutiny to minimize discriminatory laws.
Thank you. We do have a comment real quickly. Graciela Greenberg says that the ERA's failure to pass in New York, another personal experience, the ERA's failure to pass in New York in 1978 was my motivation to become a U.S. citizen in order to have the right to vote. So, Ruth, do we have any more questions in chat?
No, I don't have any other questions in chat.
Let me see if I've got any other comments here that, you know what I'm going to do is, let's see, we did abortion, we did discriminate, I think we did it. So what I'm going to do right now is, if anybody would like to make a comment, take your chat off and go ahead and make a comment, and then we will close.
I do have a question about the sense of this being able, the Congress, you know, the mood within Congress at this point. Can you speak a little bit to that sense of where our Congress is now in moving this forward?
Yeah, and the truth is, Diana, my guess is probably as good as yours because we certainly have relationships on the Hill and maintain this communication. We do strategic outreach to try to garner additional support, and it's something that we're working on with the Senate right now because this is a bipartisan piece of legislation, and we'd like to see that bipartisan support. The League is, nonpartisan. There are questions about whether movement in the Senate would be more effective if they were able to get essentially a change in rule where the filibuster was not applied to the impending vote. But that in itself requires a certain number of votes in the Senate. And again, your guess is as good as mine as to whether or not that would garner support. It's very seldom applied, so the presumption is no. We also know that the joint resolution is identically introduced in the House and has been sponsored, but there's not been an indication yet of a vote scheduled. So we know that we'll get a vote on the Senate, but we don't know if it will pass through the Senate. And like I said, the biggest emphasis right now, knowing that we don't currently have a vote set for the House, is to just demonstrate a record of bipartisan support, so that if this movement needs to continue into the next Congress, we can say, and this is the number of Congresses in which it's been introduced, and this is the support that it's garnered over time.
Okay. And I assume the toolkit gives us the means by which we can follow the legislation and or, be alerted to the actions as the, why are you shaking your head, Alice? No, it doesn't. Oh.
No, it's an advocacy support.
Oh, okay.
But Rebecca, that is a good question. Where can you follow the progress of the Equal Rights Amendment? And I think you very quickly touched on the fact that the League is partnered with the Equal Rights Amendment organization.
So Diana is right that if you go in the toolkit and you look under which senators have co-sponsored this joint resolution, it takes you directly to congress.gov and the webpage associated with SJRES 4. And that is where you will be able to find, hopefully, if they do it right on the back end, relatively fast updates about how it's moving through Congress. My presumption is we will also be putting out a press statement immediately following the vote. So that's something that we'll push out to our membership as well from LWVUS. And then with regards to the ERA Coalition, I know they have their own resources. So we do a lot of Hill meetings together. We'll send sign-on letters together, but you can sign up through their website for updates as well. And once again, I would think that their press release on the verdict of the Senate vote would be coming out pretty expeditiously.
Great, thank you.
I do have another question from chat. Rebecca, are you available to speak to other women's groups? One example would be that a group was started in Sarasota, which is very close to is the county next to us. And the group was started to help pass the ERA. So it's just a general question. Are you available, Rebecca, to speak to other groups?
I would love to talk offline. If Alice and Ruth, you can send my professional email address around. I'm always happy to look at what the particular event or speaking opportunity is, just to make sure it's in line with the League's priorities. And I'm happy to share any of our public facing resources as well. So please always feel free to get into contact with me so we can figure out the best use of all of our time and resources together.
Thank you. We will do that.
Great.
As well, if anyone, we are going to not only post this video in the video page online, it'll be the spotlighted one for the April Manatee voter, and it will have the links to the toolkit and the presentation that Rebecca prepared, the PowerPoint presentation, and any other links that pertain also to the other organizations supporting it. As you look at these, especially like Diana, and you say, gee, this status would be really interesting to people, or I really like this graphic in support of it, send it to me or send it to info@lwvmanatee.org or president@LWVman, and I'll post it on Facebook. I may use it in the Manatee Voter, but we can, if we get materials from our members, we can promote it a lot more. So that's excellent. Any other questions? Anybody have any other comments? Well, thank you. Oh, go ahead.
Yeah, so one thing I'd like to say, I've provided a lot of information. I know it's nuanced. We all learn at different speeds. Some of us are far more visual. I've had a lot of time to digest this because I've been with the league coming up on a year. So no question is silly. If there's something that is outstanding for you, or you go back through the information and it doesn't make sense, or something else arises, I'm more than happy to discuss. Again, one of the best things we can do is educate ourselves so that we can speak, you know, like I said, from a unified voice and with nuance. So any questions, more than happy to address via email.
Well, I think maybe a close where you tell us what is it that needs to happen for this. I know you said it needs to go to the archivist and it needs a joint resolution. So from Congress. So does it need both, either Biden or Congress to pass it and then send it to the archivist, or?
So Article 5 of the Constitution is what outlines the amendment process. And the only branch of government that's mentioned in Article 5 is Congress.
Okay.
Article 5 does not talk about time limit. So there is going to be a lot of back and forth. Should a time limit ever be imposed? A time limit has only been imposed in this century. If Congress can put it in, it can take it out. Congress must take action. Congress doesn't have to take action because 3/4 of the state have ratified. So there's a lot of back and forth. And even among constitutional scholars who support the ERA, like I've shared, there's disagreement about the appropriate next step. The archivist can, but for all intents and purposes, publish the ERA as the 28th Amendment because all ratification requirements have been met. But there is a heavy politicization, unfortunately, of this issue, which means that some folks are reaching out to the president and saying, push that archivist to publish. And other folks are saying, let's push Congress to address the fact that they did put in a time limit, which is oftentimes what's brought up in a court of law. Whether Congress passes this joint resolution or the president reaches out to the archivist and says publish, this is more than likely going to end up going through the courts and up to the Supreme Court. So the best thing we can do is take a multi-pronged strategy where we look at this opportunity in Congress and whether it's pushing forward with that action alert for support in this Congress or preparing for reintroduction of the joint resolution in the next Congress, whether it's writing to the president to ask him to tell the archivist to publish, we are going to need to move as an army addressing these distinct branches of government, because there is not a singular strategy. That's what makes this so complicated. The ideal is that if Congress passes the joint resolution and says the time limit is not an issue, when it ends up getting challenged in a court, the court will say, and Congress has already made this determination. But as you can see, there's not a clear path. So the league's strategy is to focus on Congress because the president has already said this is a congressional action. And there's this wonderful opportunity where we have bipartisan support and we have a history of support in the previous Congress. So that's where we're going to push our emphasis. But again, you're going to see plenty of advocates who disagree about strategy. And we do respect that folks are taking a multi-pronged approach because there's a small but loud opposition to the ERA.
Thank you. Thank you. This has been a really thorough and really wonderful presentation, Rebecca, and we thank you for it. We thank you for sticking with us while we went around in circles. And I would encourage everyone to check our calendar events on our website. We have some exciting programs. We've got on Thursday, March 23rd from 5:30 to 6:30, we have the Taste of the League this month. It's going to be a spotlight on our natural resource action team. Of course, we'll have our toast and our what's in the works, what's coming up. And we have tomorrow morning, a notice will go out about our annual meeting at the Bradenton Country Club on Saturday, April 22nd at 11:30. It's Earth Day. And our speaker is Debbie Osborne, Director of Land Protection for the Conservation Foundation of Gulf Coast. So we'll learn all about land conservation that's being done and how they choose and what's in the works for Manatee County. So if you have not already done so, we ask you to please consider joining the league, and you can do so by going to lwvmanatee.org. Thank you.